All right. Thank you everyone for joining us today for our webinar on the E-2 visa. My name is Dustin Saldarriaga and I'm a senior associate at Scott Legal PC. If you're here today, you might already know a little bit about the E-2 visa. You might be pretty experienced with it, or it might be completely new to you. And either way, this webinar is well suited to you. We really are going to start with some fundamental principles underlying the visa and get into much more detail about what we consider to be risky cases. And what we mean when we say that is typically those applications that have a relatively low investment amount. Our firm actually does specialize in these risky cases. We've handled many of them. And so in this presentation, we'll share with you some of the approaches that we take in supporting our clients when they really don't have a large amount of capital to commit to the E2 business, but regardless want to create obviously a very strong E2 application. So one thing that's important to know is that our firm was actually started on an E2 visa, and our founder, Ian Scott, is currently on an E2 visa. And that really does shape the way that we work with our clients. We try to maintain a very client-centered approach and keep in mind what we know, having navigated the process ourselves as a firm, and really translating that for our clients. A few things before we get started. This webinar will be recorded. And we'll send you after the presentation a link where you can view the presentation. We'll also send you a link to our YouTube channel where we'll post the presentation, and also we have a range of other videos that are both longer format and shorter format. And we cover a variety of immigration topics because although our firm does focus on business immigration, we handle the full spectrum of immigration cases, whether that's family immigration, humanitarian immigration, etc. So please don't hesitate to reach out to us if you have any questions at all that relate to U.S. immigration. We'll also send you after this presentation a comprehensive E2 visa guide, as well as a link where you can sign up for future webinars. This webinar is part of a series. We try to do at least 2 webinars a month, and oftentimes we'll do many more than that. So do keep in touch and do join us for future webinars if they are helpful to you or might be. So if you have questions during the presentation, please send those to us through either the Q&A function on Zoom or the chat function. And we will be monitoring those, and we'll either answer those questions as soon as they come in, or we'll save them for the end, depending on whether they are relevant to what we're talking about at the time. And fortunately, we have joining us for this presentation, our managing attorney, LeGrand Weiner, is on the presentation with me. She will be leading the second part of this presentation where we get into more details about some particularly tricky areas, specifically some business types that are seeking E2 visas, as well as some trends that we're noticing in terms of adjudications, whether that's domestically or at consulates. So you'll be seeing Kelly in the second half of the presentation. She has extensive experience preparing E2 visa applications, so we're very fortunate to have her on the presentation with us. So without further ado, I will go ahead and get started, and we will begin by talking about the basic E2 visa requirements. So the E2 investor visa is what we call a treaty investor visa. And what that means is that the applicant, the person who's applying for the visa, needs to have a passport, needs to be a national of a country that has an E2 treaty with the United States. Fortunately, there are dozens of E2 treaty countries, and they really do span the globe. There are E2 treaty countries in Latin America, Canada, Mexico, as well are E2 treaty countries, Asia, South Korea, Japan, the Middle East, Africa, Europe has a number of E2 treaty countries, Australia, New Zealand. So they really do span the globe. The way that you can find a complete and updated list of E2 treaty countries is to simply Google E2 treaty countries, and that will lead you to the US Department of State's website, where they keep an updated list of E2 treaty countries. So that is a threshold requirement. In order to receive an E2 visa as an investor or as an employee, you do need a passport from an E2 treaty country. When I say you need a passport, you actually, with very few exceptions, you actually don't even need to have set foot in the E2 treaty country. So for example, if you were born in Uruguay. Uruguay is not an E2 treaty country, but you have a parent who is a national of Italy, and you have a passport from Italy as a result of having a parent who has Italian citizenship. By having that Italian passport, you can apply for an E2 visa, even if you've never actually visited Italy. So this is a very different requirement from, say, a green card, where when nationality is referred to in the green card context, it usually refers to where you were born. That is not the case for an E2 visa. You only need a passport from the E2 treaty country. I'll quickly note that you can also receive E2 citizenship, nationality, through investment. So for example, certain E2 treaty countries do allow citizenship by investment, including, for example, Grenada. A new requirement was put in place last year, which makes it a little more difficult. So in the past, you could apply for citizenship in a country like Grenada. As soon as you receive that citizenship and the passport, you could apply for the E2 visa based on that Grenada citizenship. Now you actually need to reside in the country where you receive that citizenship for at least 3 years. So you would need to live in Grenada for 3 years before applying based on that citizenship. So obviously that is a significant hurdle that was put into place last year. All right, you must own at least 50% of the E2 treaty country. This is also a threshold requirement. If you don't meet this requirement, you immediately become ineligible to apply for the visa. And if you're already in the US on an E2 visa and your ownership share drops below 50%, you immediately become ineligible for the status. So this is a key requirement. You need to keep an eye on this. It does mean, though, because only 50% is required, you can have a co-investor. So it's possible to have two people apply for an E2 investor or for two E2 investor visas. And if each of those individuals has treaty nationality, from different countries, you can have an E2 treaty company that has dual nationality, which means they can bring employees from either of those two countries. The other owner, though, does not have to be an E2 treaty national. They can be really anyone. So for example, if you are a national of Canada, which is an E2 treaty country, you own 50% of the company. The person who owns the other 50% can really be anyone. They can be a US citizen, they can be a green card holder, they can have E2 treaty country nationality, or it can be a group of people. You can have a group of 100 people owning the other 50% of the company. The key requirement, though, is that you, as the E2 treaty investor, own at least 50% of the company. The third requirement you see on your screen, you must make an investment. So this means that funds that you personally invest into the business actually need to have been spent on the business. They cannot be simply sitting in a business bank account, for example. The government, there's really two reasons for this. First of all, the government uses the investment amount to kind of determine how serious the applicant is about the business. For example, if you're at a consulate, the consular officer will want to see that you've committed a significant amount, and they will see that as your level of commitment to the business. Now, obviously, this doesn't always make good business sense. Oftentimes, from a business perspective, it's a good idea to spend a little bit on the business and generate revenue and then reinvest in the business. That is unfortunately not the way that the consulate thinks about this. Keep in mind, these are not business people typically who are reviewing your visa application. They are government employees. And so they do unfortunately want to see that you've committed a significant amount to the business. We'll talk more about what a significant amount is But for now, keep in mind that those funds do need to actually be spent on the business. The second reason they need to be spent on the business is related to another requirement that you see on your screen. This is point 5, that the business must be real and operating. The government wants to see that you have spent money on all of the things that are needed for the business to begin operating. So what I like to say to my clients is that when you arrive for your interview at the consulate, you want to be able to say that all you need is the visa. And as soon as you get that visa and travel to the US, you are ready to start running that business, to start making sales, to start hiring employees. And part of that is showing that you have bought all the things that the business needs, whether that's office equipment, a physical office space, paying for marketing, paying for employees if you need them, paying for required licenses. So that is the other important piece of the investment requirement, is showing you have bought everything the business needs to be operational. So that's related to what you see on your screen in terms of typical E-2 expenditures. It is those things that the business needs to operate. The fourth requirement is that the business cannot be marginal. What this word marginal means, it's not commonly used in this context, but marginal in the E-2 visa context means that the business needs to financially support more than just the E-2 visa applicant and their family. So this is a business that does need to employ US workers. And the benchmark that we like to use and refer to is at least 3 full-time equivalent US workers within 5 years of starting operations. So it is, in other words, it is okay if the business does not employ US workers at the time the application is submitted. It's okay if it doesn't have employees at the time of the E-2 visa interview. However, you do want to show in your application through a business plan or through actual pay records that within 5 years of starting operations, the business will employ at least 3 full-time equivalent US workers. And again, we'll talk a little bit more about that through the presentation. We already talked a little bit about this fifth requirement. The business must be real and operating. You want to show that consular officer that all you need is the visa, and then the business will be operating once you arrive in the US. And you can also show this in your application by including documents beyond the investment schedule that I mentioned before. You can show that you have actually lined up an office lease. So show that you have a signed lease agreement where you actually have office space. Show that you've actually created the business through, for example, LLC formation documents or corporate formation documents. Show screenshots of your website showing that you're already marketing your business. And you can also take this a step further where you actually have contracts or letters of intent from prospective clients who say, I know this business is going to get started in the next few months, and I have my own business, or I need these services, and once this business starts, I will be purchasing these services or products. You can include those letters in your application, and that is strong proof to the consular officer that you really have done the legwork to actually line up prospective clients, and that once you arrive in the US with the visa, you are ready to start selling. The sixth requirement you see on your screen, you must be coming to the US on an E-2 investor visa solely to develop and direct the E-2 business. When you come in on an E-2 visa, you do not have general work authorization. You cannot work for any company. You are coming to the US to work for the E-2 company, to develop and direct it. So what that means is that you really are, going out, finding business, you're growing the business, you're finding opportunities. In terms of consular applications, that is usually what is important to show, is that you're going to be developing and directing the business, that is going to be your purpose in the US on the visa, and that you're qualified to do that through your educational background and through your work experience, which you'll show through a resume. If you're applying through USCIS, which means that you are physically inside the US and you're applying to change your status to E-2 visas, E-2 status, then there's a heightened level to this requirement, and USCIS is going to want to see that you are not providing direct services to customers. Instead, you are really the one who's growing the business as the entrepreneur, as the business owner. It's helpful to use an example to illustrate this. If let's say you're an accountant and you want to start an accounting firm in the US. If you are applying through USCIS, you do want to show that you actually have at least a part-time accountant who is going to be providing accounting services to clients. You do not want to show USCIS that you're going to be the one who's providing accounting services for the first couple years, because USCIS wants to know that you are not competing with the domestic labor market. If you are acting as an accountant, you are, in the eyes of USCIS, taking that opportunity away from other accountants, as opposed to being an entrepreneur. An entrepreneur does not compete with other entrepreneurs. Any entrepreneur can create the business. It's an open market. So that's an important distinction, again, if you're applying within the US through USCIS. At a consulate, they tend not to focus as much on that. So if it does take a year, 2 years before you hire your first accountant, to continue with the example, at a consulate, that's usually not a problem. It is through USCIS. And finally, requirement 7 that you see on your screen, you must have the intent to return to your home country upon the expiration of your E-2 visa. The E-2 visa is what we call a non-immigrant visa, which means it's a temporary visa. It is not a green card, and it does not directly lead to a green card. So what the consulate is looking for, and what the border officials are looking for when you enter the US, is that you really do intend to leave the US at the end of your status. And it's usually not hard to show this in an application. We would typically include a signed statement where you explicitly say you intend to leave the US upon the expiration of your visa, and that's fine. So who can apply? We already touched on this to some degree. You do need to have the nationality of an E-2 treaty country. You can find that list by Googling it. There are a number of options to obtain an E-2 visa. You can start your own company. You can also purchase an existing company, or you can start a franchise. All of these are viable options. We have clients who follow each of these 3 paths. Something that's important to know is if you are purchasing an existing business, you do want to be able to show that it's a business with a good track record of employment. And that's because if you're buying a business that's, say, 10 years old and it's never employed more than 1 employee, you will have a hard time convincing the government that you will meet that employment requirement that we mentioned before, at least 3 full-time employees within 5 years. So ideally, start with a business, if you're buying one, that already satisfies that employment requirement. Again, we're focusing in this presentation on risky cases, and oftentimes that would be a startup. It would be you starting your own business. We have seen a lot of success with those, and again, we'll talk about some of the recommendations for navigating that process in this presentation. For how long is my E-2 visa valid? This depends on what's called reciprocity. The US has reciprocity agreements with all of the E-2 treaty countries. And basically what that means is, if one side limits the length of the visa, the other side will limit the length. So the maximum period of time that an E-2 visa can be issued for is 5 years. The shortest amount of time is 3 months. And that really does depend on your country of nationality. So you can also find this by Googling it. If you search US Department of State reciprocity, and then you click on the E-2 visa for a given country, it will show you the number of months that the visa is valid for. So there are certain strategies. If you're from a country that has a 3-month validity period, you may need to plan to apply once you get the visa and enter. You may need to plan to apply to extend it domestically rather than going to the consulate, but we can talk in more detail through a consultation if that's something that affects you. One quick note, visa validity is completely different from status. So if you, let's just take an example, if you are granted a 3-month E-2 visa, uh, each time you enter the US, you should be given 2 years of status. So you get your visa, it's good for 3 months, you enter the US, and they give you what's called an I-94. That I-94 should give you E-2 status for 2 years. The moment you leave the US, you do need to re-enter on your visa. And again, if it has a 3-month validity, you only have 3 months to enter the US on it. But each time you do enter on the visa, you should get 2 years of status. So that is significant. If you have a 5-year visa and you enter on the last day of that 5-year visa when it's valid, you do get another 2 years as long as your passport is valid for that period, or at least you should. How much investment is enough? The government doesn't give a firm dollar amount here. What they do say is that it really does depend on the type of business, and they offer something that's called the proportionality test. Let's talk about what that is. So in terms of the type of business, when we're talking about risky E-2 visa applications, a lot of the time we are talking about service-oriented businesses, such as a law firm like ours, which does not require a lot of money, or this could be a consulting firm. So for those types of businesses, you could spend, $20,000 and really have everything you need to start the business. Possibly even less than $20,000, because really all you need for some of these businesses is a computer, a small office space, and a website, and you can get going. So again, the government doesn't really care. You do need to show them that you have invested what they consider a substantial amount. So, a service-oriented business, if it does require a lower investment amount, you want to show that you've spent all of the funds that business needs. And certain areas that we might focus on, if you've hit that dollar amount and you're still relatively low, you could oftentimes pay for example, an office space in advance, pay for a year's worth of rent or 6 months worth of rent, and that would count toward your investment. You can also increase your marketing expenses, which hopefully would have a return on that investment, and would boost your investment amount. We do, of course, try to avoid ever recommending that you spend money just for the sake of spending money. And we do work with our clients to try to find ways to boost the investment amount that actually does benefit the business in the end. We'll talk about that a bit more on the next slide. So let's talk quickly about what the proportionality test is. What this is referring to, this is something the government talks about. Basically what it means, it's a sliding scale. And if the type of business requires relatively little money to get started, the government wants to see that all of that money has been spent. So for example, service-oriented business costs $100,000, say, the government wants to see that all of that $100,000 has been spent. In contrast to a more expensive type of business, say manufacturing. The example the government uses is a $100 million business, let's say a manufacturing business. The government is not going to require that all $100 million have been spent on the business. They will accept a lower percentage of that amount. And their example says 10% of that amount. They say, if you spent $10 million of a $100 million business, we may consider that to be sufficient. So that's all the proportionality test means. Frankly, in practice, and since we do deal with a lot of these risky cases, you're very rarely looking at those extremely expensive $100 million businesses. And most of our clients are at the lower end of the spectrum. I would say really anything under $100,000 we would consider a risky amount, meaning you need to be thoughtful about how to strengthen the application in other ways outside of the investment amount. But even our clients who are hitting the $1 million level, we do encourage them to try to invest everything that's needed for the business and hit that 100% mark. So I do think that's a good kind of goal to strive for, to show the government you really have spent everything that the business needs. If you're buying a business, usually the fair market value is sufficient. So, that kind of does simplify it. You do want to make sure that the business is marketed on the open market and is not kind of a internal family deal, for example. We'll talk a little bit more about that. But if you are buying a business, and it's advertised on the open market, the amount you're paying would usually be considered substantial. Finally, franchises tend to have their own fees, the set fees that a franchise costs, and then typical marketing expenses. If you're starting a franchise, usually the amount that's laid out by the franchisor would be considered substantial. We rarely see franchises where the amount that's required to start the business is not considered sufficient. If you have a low dollar amount, so again, we're focusing on risky cases, and what we usually mean there is either a low dollar amount or the type of business. Kelly will talk more later about the type of businesses that are risky. I'll focus here. If you have a low dollar amount, what can you do? The first thing to do is what I said before, is to consider ways to boost your investment amount in a way that still benefits the business. That could be paying for an office lease in advance. It could be increasing your marketing expenses. One of the key things you can do, one of the most beneficial things you can do, is to hire an employee. This doesn't need to be a full-time employee. Frankly, it doesn't even need to be a W-2 employee. It could be an independent contractor. But think about, is there any role that I can pay someone to perform? It could be marketing. You could hire an independent contractor to design your website or to spearhead your marketing campaign. That's the kind of thing that when the government looks at your application and sees that you're already paying a worker, it kind of takes away some of the consular officer's focus on other aspects of the application. And that is because when the government looks at these applications, at the end of the day, what they want to see is that this is a business that is likely to employ US workers. And if you can show the government, I'm already employing US workers, then they're going to be less concerned when they see a low dollar amount. Now, that doesn't mean that the investment amount becomes irrelevant. It is still relevant. It is just less significant if you can show that you're already employing US workers. And that's what, when you look at this slide, that's what we mean by looking at the overall strength of the application. If you go back to the first slide where we looked at all the requirements, remember that one of the requirements is to employ US workers. So, you want to look at that. You want to look at things like interest that's been expressed in your business. If you have strong interest from prospective clients, again, the overall investment amount might not be as critical. So again, if you're working with a limited amount of funds, or you really have spent everything that this business needs and spending more really would be a waste, it is time to start thinking about how can I strengthen the application elsewhere? How can I really show that I have strong demand for my products or services? How can I show that I'm already employing, a worker or an independent contractor, and focus on those aspects of the application. I also have on the screen, consider getting a letter from a local chamber of commerce, chambers of commerce, or really even a local government entity that says it could be small business services, for example. Many towns and cities have those, where they say, we are aware of this company that they are looking to apply for a visa to start this business. We do think that would have a positive impact on the local economy. We do think it would create jobs for our economy. That's the kind of thing that really is significant in these applications. So get creative and consider pulling together that evidence for your application. A strong business plan. So if you can't hire workers before you apply, a business plan really is a key piece of the application. And that is because a business plan is really where you show the government that you are going to employ US workers if you don't already have them. A business plan needs to have strong financial information as well. So you can't just provide a business plan that shows hiring projections. Those hiring projections need to be supported by projected revenue, projected expenses, and projected profits, which all of those need to be supported by reasonable financial assumptions. So a strong business plan is going to make clear to the officer, what your assumptions are, how many people you're going to sell your product to, what you're going to charge for that product, how you're going to get interest in your product or your services, and how that's going to lead to profit and how that's going to lead to the employment of workers. So a business plan is really key if you have a risky case, low investment case, particularly if you have no workers. Excuse me. And you see a couple examples on your screen. These are just two extreme examples. Excuse me. The first one is really putting into practice some of the things we've talked about already. Low investment amount, but you've already hired 2 US employees and you're already selling a product. That could be a strong case. Versus example 2, you're applying for a visa, you have a low investment amount, but you don't want to invest more. You're worried about investing more. You don't want to hire anyone. And so you really are applying based solely on projections and a business plan. That's relatively weak. One question that comes up a lot is, well, I'm outside the US. How do I satisfy example 1? A great way to do that is to hire someone within the US who can act as your manager and may begin conducting interviews, might begin actually selling your product or service while you're abroad and actually getting some traction in the company. We do see that quite often, so it is possible to do that. So let's quickly talk about common E-2 visa expenditures. I already touched on this. These are just things that the business needs. So inventory if you need it, equipment, and paying for all the things that you need to set up the business. Entity formation expenses, legal fees, licenses, etc. What are weak expenditures? Travel expenses, expenditures, entertaining prospective clients. Don't include those in your application. So again, what you really want to show through your investment is that you've bought everything that this business needs to become operational. I see one question which I'll quickly address. What are a few common businesses that doctors can use for an E-2 visa? Really, any medical office could satisfy the E-2 visa. Keep in mind what the requirements are. So as long as the business requires a substantial investment and will employ US workers and you are actively developing and directing the business, odds are it's going to satisfy the E-2 visa requirements. So for doctors, you could start a medical office. We do see that happen with some frequency. And with that, I will pass it off to Kelly to talk about common challenges with consulting businesses.
Thank you, Dustin. Thank you for that, very detailed background. I think gives us a good framework for talking about these types of risky cases. I think that, consulting businesses are a business that we do very frequently. That being said, I think they often are riskier types of cases. So there's, sometimes we have clients who come to us and say, oh, some other attorneys kind of, recommended that we not pursue this. So I think it is very possible to get an E-2 for a consulting business, but there are some, really extra considerations that you want to keep in mind when you're doing this. So the, very, very common question, we get or statement from clients is, I want to start a consulting business, but I don't really need to invest any money. I have a laptop, I have my own expertise. That's all I need to start my business. So fundamentally for an E-2, this is an investor visa. So even though, from an entrepreneurial perspective, you don't actually need to spend any money to get the company up and running, in order to get the visa, this is a requirement. You have to invest a substantial amount. So, what you want to do is you want to, as Dustin, I think mentioned earlier, is you want to think about what expenses might I have in the first couple of years of operations that perhaps I could just pull to the start. So maybe I wouldn't pay for a really advanced website, or maybe I wouldn't contract with a PR firm. Perhaps I would wait to hire an employee. Perhaps, I would, along with that, I would wait to, purchase a better laptop or more office equipment. But you would then think about, okay, well, maybe I'll purchase those things now. Maybe I'll make those investments now, because I would be spending that money down the road anyway. And this is what I need to get the actual visa. Another challenge I think with consulting companies is there's really a concern that you're going to come to the United States and just operate as a solo consultant. And that's not what the E-2 visa is for. The E-2 visa is for an entrepreneur that wants to develop and direct a company that's not going to be marginal, that's going to make a substantial economic contribution, and that's going to hire US workers. So in order to kind of ease that concern for the officer, one of the most beneficial things you can do is perhaps to hire an employee before you file. It's not a requirement, but it does greatly strengthen your case. And another benefit is that anything that you pay, so let's say you hire an employee, so then you have to get maybe a payroll provider set up, you have to get, insurance related to that. So any of those expenses that you pay in order to kind of get the employee onboarded and then to actually pay the employee for their services, that's all included as part of the E-2 investment. And those are great E-2 expenses. And then they'll not only help with the substantial investment part, but they also help with the marginality part. And they can also help with the real and operating part because that employee may be able to do some things in terms of getting client contracts signed or getting clients kind of, going in a way that you may not be able to do, if you don't have work authorization yet. So I think that for a consulting company, let's say particularly if perhaps you've operated a consulting company for many years and you had never hired anyone, I think it can be really, really beneficial, to hire an employee. Other things that you can do that you can spend money on. So, for office space, you can prepay sometimes for 6 months or 12 months. Another piece of that is perhaps you can get a provision in the lease that indicates if the visa is not approved or you end up not going ahead, that you can get some of that money back. So that might help protect some of your investment. You can also purchase equipment, you can invest in marketing. That's always very helpful. Another concern with consulting companies sometimes is there's so many consultants, how will you differentiate yourself? Is there really a market for your services? So to the extent that you're able to provide contracts, letters of intent, anything that indicates that you do have clients that actually are interested in your services, that can also be really helpful in easing the concern of the officer that you might come in and, the business will kind of go, really can't count as real and operating because you don't have any clients in the pipeline yet. So all of those are things that I think can really strengthen a consulting business and make it much more viable, from the E-2 perspective. All right. So another type of business that I think is very common, but also can be very challenging are kind of real estate businesses. So many consulates even have this on their website that you cannot purchase a property, put it into, maybe an LLC and have that be your investment. That is considered, just buying a property and owning that property. That is not, that does not work for an E-2. It's not considered a real and operating enterprise. And it's just a very common kind of misconception that people have sometimes that they can make an investment by just purchasing a residence and, or maybe having a couple Airbnb properties and making that work from an E-2 perspective. So the challenge with a real estate company is, showing that it's real and operating, that it's actually generating income, that it's not just an idle passive investment. So you don't have just own a property and maybe you have a tenant in that property and you're collecting, passive income. So, some ideas that have worked, for our clients. So sometimes a real estate brokerage firm, a real estate management company, sometimes renovation or construction. Also house flipping. But if you're going to be doing house flipping and that's your main activity, then it needs to be done really on a large scale. So where you're looking at really commercial real estate development, or we've had sometimes people that are doing residential development, perhaps, and they're flipping 30 to 40 homes. So when you think about that, you also, need to recognize that if you're doing house flipping and that's your main activity, then your investment amount is likely going to need to be very high because we're talking about developing a large number of projects and usually there'll be lots of ongoing expenses associated with that. So, for our clients that have done these types of house flipping E-2s, usually their investment is somewhere, close to or over, 1 million, 2 million, $3 million. So that's really, something to consider in real estate. It's very possible to perhaps, maybe you want to do some house flipping, but you don't have that amount to invest. Perhaps you do a different type of real estate company. So maybe you work as a property management company. And then another aspect of your company is that there's some amount of, house flipping that is involved in that. So that's something you can also do to kind of incorporate multiple ideas. And as much, the benefit of kind of the property management is you're showing you have a real and operating enterprise. Property management is service-based, so you're not really needing to invest such a high amount. But then if you also want to do house flipping as part of your activity, you can also incorporate that. One last thing I'll say about real estate is just, there's often a lot of licenses that are needed to do this type of work. So if you're a real estate broker, if you're doing construction, if you're doing anything related to that, very often there are kind of local city, state requirements related to this. So you always want to kind of research that in advance. Perhaps you partner with somebody who already has a license, until you're able to get your license, or you make sure you're in a position to get your license ahead of time. In certain states, you need a social security number to get a license, or they have, particular residence requirements. You always want to research that in advance, because if you get to the interview, they may ask you about that. Do you have the proper licenses to run this type of business? And if you don't have that, then they may find that the business is not real and operating. Or if you're in a situation where you haven't researched it and you don't know that, it's going to take 6 months to get this license, that can be problematic. So you do have to research that in advance. And kind of have a plan for, how you're going to respond to those questions, at the consulate or with USCIS. So we'll talk also about, equity trading companies. So this is another one, I think, very, very similar to real estate in the sense that the main concern here is that that the officer will think the business is not real and operating, that perhaps you've just taken your stock portfolio or you're just trading kind of more casually for your friends and family. So, you always want to make sure that you have a really strong business plan that shows that you are going to be marketing outside of just, kind of yourself or maybe a couple of friends or family. And then the other piece that's very similar to real estate is this is a very highly regulated industry. So often there will be kind of a very complicated corporate structure. Maybe there's a fund, there's a partnership, so all of that kind of needs to be very clear and explained, at the consulate. And you also need to make sure that either you have the appropriate licenses to run this type of business, or you've done the research to show you don't need those licenses, or perhaps you partnered with someone who has those licenses. All right, so let's talk a little bit about kind of some of the reasons, we see for E-2 denials. So one is low investment amount. So I think we've talked a bit about this today. There's some investments that are just too low, right? So if you're investing $2,000, this is just not going to be enough that the officer will believe you've invested a significant enough amount to commit to, running the company. So we've had situations perhaps where people have come to us, maybe they filed without a lawyer. And they spent $2,000 and put $98,000 in a business bank account. So this is just too low. There's not enough money that's actually at risk and irrevocably committed. We worked with them to get their investment amount higher. They ended up spending around $50,000, had around $50,000 in the business bank account. They reapplied and they were approved. So the benefit of being denied for a low investment amount is there are things you can do to mitigate this. If you do have more money to invest, if perhaps you kept a larger amount in working capital, perhaps you spend some of that. You can also go and perhaps have a CPA, evaluate your business plan and your investment and write a letter confirming that you've spent everything necessary to run this type of business. Additionally, you can look for industry reports or reports from kind of trade associations that talk about what are the normal startup costs for this type of business. And you can include that in your application to say, here is some objective evidence from, respected business publications or market, reports that indicate I have spent a substantial amount in light of the total cost of setting up this type of business. So another reason for the denial, nature of the business. So we've just talked about some kind of the more risky categories. So consulting businesses, real estate, equity trading. I'd say that, very, anecdotally from many clients, when they have gone in for real estate types of businesses, it's very common that the officer will kind of, maybe ask more questions at the interview. They'll have a little bit more that they want to know. Or perhaps if it's a consultancy, they'll really want to dig in to see, okay, do you meet each of the E-2 requirements? Are you planning to hire? Do you have the appropriate licenses? So if you're going in with that type of business, you just need to be very prepared for that interview. So another reason is filing location. Venue is very important. It's over the years, kind of trends at consulates change. The officers that are posted at various consulates change, and the way that e-visa units adjudicate these petitions change. The law actually has not changed, but you're dealing with a consular officer who is interpreting the regulations in a particular way. And so it is important to kind of speak with your immigration attorney, to understand kind of what are the trends at the consulate you're applying at. Are there certain consulates that just will not, approve cases that are under a certain dollar value, and that changes over the years. So you want to just speak with your immigration attorney and really consider venue, because it can be quite important. So these, the next two are kind of related. So let's say that you had a business in your home country for many years and you had never hired any employees. So there is a concern. Will you hire workers in the US? Will you meet that marginality requirement? So if you have a track record of running a business, but you've never hired employees, this can be a red flag. This is something where now, even if you have a 5-year business plan stating you'll hire employees, you also have a track record showing you did not hire employees in the past. So that's a situation where you really may want to, strongly consider hiring an employee before you file, to just help address that concern. So another is issues with the adjudicating officer. So, when you're coming in for your interview, consular officers are human beings. Sometimes they, especially right now, we're seeing a trend of many, many new officers because there was kind of a lot of turnover during COVID. And there's just officers that maybe take a different approach, or as they're learning or as they're being trained, they, kind of will take a particular view with a case. So, ultimately, if you are denied, there is an ability to reapply. You're not, the denial is not kind of prejudicing you from reapplying in the future. Many consulates will try to give you a different officer if you reapply. It's not guaranteed, but many of them do try to do this. So if you feel that, you had a really bad interview, that the officer just didn't understand your business, it is possible to reapply, and very often you will get a different officer. And then finally, it's just, concern of, did you not meet the requirements at the time of filing? We do have people who sometimes come to us after the fact. Perhaps they filed on their own, and, maybe they just didn't meet the requirements. So, they didn't own 50% of the business. They weren't, all the money was just in cash and not committed. In those types of situations, you just don't meet the plain language of the regulations. But, as I mentioned, you do have an ability to reapply. So that is possible to do. So let's talk a little bit about some e-visa adjudication trends. So I think COVID is, unfortunately still impacting E-2 visa processing. There are some places where, e-visa processing really hasn't come back in any real way. So thinking about in Bogota, in Colombia, they're just starting to process e-visa cases that were filed in September of 2020. So that's a consulate that's still really, struggling to get back on its feet. However, there are other consulates where e-visa processing has returned, relative normality. So thinking of Toronto, London, those are two consulates we process at frequently, where I'd say in both cases, there's, I'd say, a bit more of a lag in appointment availability in Toronto than there used to be. But you still are able to submit your application, get a response usually within about 10 business days, and then able to book an appointment usually within a couple of months. So there are consulates that are, pretty much back to normal. And then there are consulates that are still really struggling. So again, very important to discuss with your immigration attorney about where to file, because it does make a significant difference sometimes, as some places are really delayed months or years, and some places are really operating on a very normal timescale. In terms of extending status in the United States, that's an option. So it used to be, when we look at USCIS versus the consulate, I would say for the vast majority of clients, our recommendation is, file at the consulate. The reason being that you can actually get a visa stamp in your passport that allows you to travel internationally. For many people, they could even get up to a 5-year visa stamp. However, there are some countries, Bangladesh, for example, or Egypt, where you only can get a 3-month visa stamp. However, when you enter, you can get 2 years in E2 status. So usually we would recommend the consulate for that ability to travel during COVID. And I think even sometimes now, depending on where people need to file, USCIS can be a good option. If you enter the United States and you're in a valid status, for example, B1 or B2, F1, not ESTA. ESTA doesn't permit you to do this, but if you're in a different type of valid status, you can apply to change your status to E2. You don't get a visa stamp, but what you do get is a up to 2-year approval that allows you to stay in the United States and run the business. With USCIS, there are some, benefits and drawbacks. So one benefit is they are much more receptive to very low investment amounts. We have sometimes processed, investments as low as, $35,000, $40,000, with USCIS, where I think many consulates are much more resistant to that amount. That being said, USCIS also asks for a very strict dollar for dollar accounting of the source and trail of your funds. So whereas, for example, at a consulate, perhaps you would go and you'd say, this is my personal savings from employment. You might provide some tax returns, maybe proof of the wire transfer of the funds to the US. With USCIS, they would actually want to see that the payroll hitting your bank account, being accumulated in your bank account, and then the exact trail of it being transferred to be spent on E2 expenses. So if you have a very complex source and trail of funds, or you receive the money in many different ways and many different transfers, it may be that a consulate is a better choice for you, because USCIS might be quite difficult to get approved with that complexity. All right, so some other kind of issues and complex areas with E2 visas that have come up. So do you have to hire employees before you apply for a visa? No, you do not. This is not a requirement. That being said, there are some consulates that really, really prefer to see this, and it can be very beneficial, as we've talked about earlier in the presentation. So other, complicated source and trail of funds. This is particularly the case for USCIS filings, as I just mentioned. I anecdotally have a case, where the person received the money from a, sale of a business, in the 80s. And USCIS still required that purchase sale agreement. They required a trail of the money. Where did it go? What were taxes paid on it appropriately from the 80s up until it was actually spent? So they will look back to see exactly where the money comes from. And, very important to make sure you can document that if you're going to file with USCIS. Loans are acceptable for E2 investment if they are collateralized by your personal property, so not by the business. They cannot be, you can't kind of have a loan that's secured by the assets of the E2 business. That doesn't work, but either an unsecured loan on your personal signature or a loan secured by your personal property, those are both acceptable for E2 investment. You can also get a gift. But you cannot avoid the source of funds requirement by getting a gift. So if somebody's giving you a gift, then they need to be willing to provide the documents to show where they got the money. So you need a gift letter and then also their financial documentation and then proof of them transferring that money to you. Another thing that comes up a lot, people will ask, can I get 2 E2 visas for 2 investors? Yes, you can. That's possible, but the ownership needs to be 50-50, if you're both going to be E2 investors. Otherwise, if you're of the same nationality and you want to own, a different percentage, 60-40 or 70-30 or something like that, then the person who doesn't own the 50% would need to be an E2 employee. But that would only work if you have the same nationality. If you have 2 different E2 treaty country nationalities, then you would have to own 50-50. Looking at kind of substantive changes to, the E2 business after filing, I think this comes up a lot. People sometimes will get their visa. They say, great, I have a 5-year visa. I can do whatever I want in the United States. This is not the case. You have been granted a visa to run the business that you submitted to the consulate. So if you have kind of expansive ideas about what you want to include in the business, you should outline those in the business plan, so that, the consulate is aware of the type of business that you're going to be running and you've gotten that approved. If there is a change in the ownership, so, you drop below 50% ownership, let's say the company is no longer majority owned by treaty country nationalities, now your visa is no longer valid. So even though the dates are valid, technically, ultimately that visa is no longer valid because you no longer meet the requirements. Similarly, like when we look at changes in the type of business, so if there's a change to the business that's kind of a natural outgrowth of what you were doing, like let's say you're doing a marketing consultancy and you plan to focus on, finance, as your main clients, but ultimately you ended up, dealing with a lot of kind of real estate clients because that was just the niche that you fell into. So that's very similar, right? You're still offering marketing consultancy services just to a kind of different niche area than you planned. That's not something that would be considered a substantive change. But let's say that you are a wedding photographer and now you want to open up a restaurant. So these are completely different, lines of business. So before you would be allowed to open that restaurant, you would need to go back to the consulate or to USCIS, get that approved, likely need to prove a new investment. So there's not an ability to just change the business entirely without getting an approval first. And then finally, just family business purchases. I think Dustin, had talked about this a little bit earlier, which is, if you are purchasing a business, often and it's on the open market, the fair market value will be considered a substantial investment. If you're purchasing a business from a family member, it's really a good idea to get an appraisal of some kind from an objective third party. Ultimately, these types of transactions will be scrutinized, much more closely. And if there's, for example, a very successful business, the financials show lots of assets, lots of profit, lots of revenue, and you're purchasing it for a very low amount from a family member, that's going to invite a lot of scrutiny. So if you're doing a family business purchase, you really want to do everything necessary, to get that objective third-party evaluation to show that the amount that you're paying makes sense in light of, the type of business that you're purchasing. All right.
So yes, we have wrapped up the presentation portion. Kelly, thank you for the great information. And now I know a few questions have come in. We've answered a few during the presentation, so there are just a few, excuse me, outstanding. Kelly, I think the first is, what about spouses? What can they work? And if so, what is the scope of their work authorization?
Sure. So E-2 spouses can work. And there was a very beneficial change that happened in the last couple of years where they previously needed to apply for work authorization. Now they no longer need to do that. When they enter the US, they should make sure that they were granted an I-94 under the category E-2S for E-2 spouse. And that I-94, is sufficient to show that they are permitted to work and they can work anywhere in the US.
Perfect. And then we have a question in terms of USCIS. If you apply to change or extend your E2 status within the US, how long is that status typically granted for?
2 years. Yeah. So that's the longest that it can be granted for.
Perfect. And then I will answer this last one since I did the Google search to confirm. So how many months or years is the E2 visa issued at the US consulate in Chile? Is it the same amount of time, whether it's the first time or a renewal? So for Chilean nationals, an E2 visa can be issued for up to 12 months, so only 1 year. And just to be clear, the reciprocity applies not to the consulate that is issuing the visa, but to your nationality. So if you are a national of Canada who's applying at the consulate in Chile, you will be issued the period of time that Canadians can be issued for, which is 5 years. If you're a national of Chile, though, and you apply in Canada, you're going to be limited to a year, since nationals of Chile are limited to a year. So do keep that in mind. And the last thing, the other two things in this question, so a renewal or a first-time applicant, it really doesn't matter. What does matter, if there's anything in the application to suggest that you don't need the full period of time, such as, if you say you only need a visa for 2 years, they may not issue you a visa for 5. But otherwise, they will usually issue it for the maximum period of time, regardless of whether it's an initial approval or a renewal. Residency requirements for someone from the UK. Do you want to answer that one, Kelly? And then we'll wrap
Sure,
up.
sure, absolutely. Yeah. So the UK is one of those, it's kind of a special visa for the E2 in this sense. Most, as Dustin had previously alluded to, most places, if you just have the passport, that's sufficient. For the UK, it's actually not. You actually have to be a resident of the UK. So let's say that, you were born somewhere else, but you have a UK passport, but you've never lived in the UK, you will not be able to get an E2 visa, in that scenario. So generally, the consulate will look holistically at the residency requirement. So, like, let's say that you've lived in, the UK for most of your life, but perhaps you went and worked abroad for even, 5, 10 years. At that point, I think, before applying for the E2, generally you should move back, and be in the UK for some period of time before reapplying. But as long as you had, some ties to the UK, you'd lived there for some, period of years, even if you've been out of the US or I mean, out of the UK for a bit, you can still qualify, but you do need to be willing to move back. You do need to be willing to be in the UK for a bit to build up that residency documentation to show that you are, holistically should be considered a resident of the UK, even if you've been out of the country for a few years.
Yes, great question, great exception to that rule that I said before. Um, we are up against the end of our time. I know one question came in about consular processing times. It really varies by the consulate. As a general rule of thumb, it is taking typically at least three to 4 months. But for more specific information, do schedule a consultation. We can talk through the business idea as well as your options for where you can apply. So Kelly, thank you so much for taking the time and sharing your expertise. And to all of the attendees, great questions. Thanks for sharing your time with us. Do keep an eye out for our follow-up email where we'll send you the presentation and a link to the recording, and we hope to see you on future webinars. So thank you so much.
Thank you, Justin. Thanks, everyone. Have a nice day.